It's fine now.
Okay.
That's why we met.
What proves the fact that the EC did not try to coerce the petitioner into accepting the disqualification?
I met. I've on record. I've tried meeting all aspirants, apart from one who is Fana Jessica of. She's in Hawaii, so I've not met her. But of all aspirants, I've tried meeting them, and in my meetings with them, I let them know that the vetting was thorough, and although they didn't, the vetting was thorough, and it's just unfortunate they couldn't make it. That's all I make. And rescinding the decision will be very difficult for the EC. That's what I made. And on the said day, I told Mr. Brides, he left me, he said he's not going to say anything. And came back again with Mr. Emmanuel Apalu and said whether his name can be put back on the ballot. And I told him, no, it can't be done. And I said, that is it. The EC has made this decision. The vetting panel has made this decision, so it can't happen. And he texted me again saying that he wanted a feedback for us. And I said, from us. And I said, I can't give him any feedback. Then I told him after that the decision stands. We can't rescind our decision. So the meeting was to just let him know that as EC, we can't change our decision. And our decision stands. So he trying to say I was trying to cajole him to accept the results. I don't know how it happened.
Okay. My lords, I would like to make clear the fact that the petitioner states that it is said that the petitioner came back to ask whether his name could be put back on the ballot box. And then I would like to ask if he indeed accepts that the basis for disqualification is unconstitutional. Why would he come back again to ask the EC to put his name back on the ballot box? Since if we are going by what he's saying, the whole process is compromised. Okay. So my next question is, can you tell the court the events and happenings of the said meeting? What ensued during the meeting? What you said?
I just told him that the EC has made this decision. It will be difficult to resign. Changing it would make the EC bad. So that's it. Our decision stands. I didn't tell him that I should accept the result that he's purporting. I didn't make mention on it. And he said, I'll hear from him. And he left. So I was there again, and I think an hour or two later, I was at a ward round. So, yeah. He called.
What was his mood when he left? Was he angry? Was he irritated?
He didn't say, he didn't react when I told him. He said I'll hear from him. That's what he said. So I was there again, and he called me. And this one, he came in the company of Mr. Emmanuel Akbalu and asked whether
He called you?
Yes.
Okay.
He called me back to meet.
The second time he was meeting?
Yes, on the said day. He called me back again. Okay. He was trying to lure me. Yes, into bringing him back on the ballot. And I told him it can't happen.
Do you have proof to that?
I don't have proof, but that is the conversation that went to.
Okay. My lord, I would like to read the meaning of coerce by the Oxford Dictionary. It means to gently and persistently persuade someone to do something. And so by what the EC chair says, the statement that the EC tried to coerce the petitioner into accepting his disqualification is also factually incorrect, since there's no event in which the EC gently and persistently persuades the petitioner into accepting his disqualification, per what the EC chair is saying. Thank you. Okay, my last question is, how many people were present as at the time the meeting between the EC and the petitioner?
So the first meeting was between I and him, and it was very short. It didn't even last up to 5 minutes, because after I spoke, he said I'll hear. And the second meeting, Mr. Emmanuel Apalu came later in his company.
The second meeting of which he initiated?
Yes. He brought Mr. Emmanuel Palu.
He brought Mr. Manuel Palo.
Yes, please.
Okay.
And that one, they were trying to, quote, lure their way back on the ballot, and I told them it can't happen. The decision of the EC stands. And I made him know that. So he was waiting to get a feedback whether it will happen or not, because he texted me that he's not gotten a feedback. And I told him, no, please, there's no feedback. So I texted him a day later and told him we can't rescind our decision. So that's it. Thank you.
Okay. The day you presented the CI before Parliament, was the CI approved?
No, please. So when I presented the CI, I was given some few days. I think some issues were raised as to the first issue that was raised was whether we could use the manual system of voting. There were issues of sandwich students and a whole lot of issues. So I was made to go and do a little bit of research on how we could combine the two systems, whether it was feasible to do that. So I was given like, I think 3 days, 4 days to, I can't remember, but an ample amount of time was given to me to try and correct the suggestions, or to try and put the suggestions of the Parliament into the CI. So within that period, everyone was given the opportunity to read it, and also
Everyone was given the opportunity.
all parliamentarians were given the opportunity
All
to.
parliamentarians were given the opportunity.
Yes, and also on the said that the CI was finally approved, time for questions was allowed for anyone who had an issue with the CI before it was finally voted on to be accepted.
Okay. I rest my case.
Thank you. So, counsel, you can take your seat, and we'll have the counsel for the petitioner to cross-examine the Electoral Commission now.
Mr. Restford.
Yes, sir.
Okay. So you said you did have a meeting with my clients.
Yes, please.
Can you go over again what happened? I mean, the ending part of the meeting.
Here, Mr. Palu was, I think, the
Not
second.
that one. I mean, the first one.
I told him that the AC did a thorough work. We have vetted, and unfortunately, he couldn't make it. But we rescinded our decision. It will be very difficult. So I told him that, and he said I'll hear from him. I first asked him how he was taking the results, how he's doing this, and he didn't seem to be open to me about responding. So I just went straight and he asked me, and he told me that I called for the meeting. So I needed to should I say start the meeting. So I started and told him, and he said I'll hear from him, and that's why I left. So I didn't have any issue again.
Okay, you said the meeting is not a clandestine meeting, right? Because you informed your first deputy.
I didn't say it wasn't. I said I informed my first deputy, but I didn't say it wasn't a client. Please don't put words in my mouth.
But your lawyer asked you a question that the meeting wasn't a clandestine meeting, and then you said yes, and he gave us the meaning of clandestine, and then he continued saying that because you informed your EC or your deputy, your first deputy, it means that the meeting is not clandestine. And now you are telling us that you didn't say that. In fact, listen, you said a whole lot of things that actually contradict to yourself. And I doubt that all what you have been saying, if it can be believed or it can be, we can say that what you are saying is even true. Because you don't have any evidence to prove any of the things that you are saying. Now, I have a chat with me over here about how after the meeting and after everything, he's continued to send him a message that the election or the result that have been received is purely like from the EC, and then no one has forged the results, like that kind of thing. That was the impression of him sending that message. After he has finished having the meeting with my client. But the thing is that when he was talking, he said he told him that the very day that he met my client. Yes, please. I'm asking the question. This part. So the question is that he said the meeting is not a clandestine meeting because he informed the first deputy. And now I re-asked him that same question again, and he said no. Meanwhile, he has already said yes in some of the statements that he has made over here, which means that he's actually contradicting himself. He doesn't know what he's even talking about. So what is the proof that all the other things that he's talking about is even true? Even with just this simple question, he is still contradicting himself. What is the proof that all the other things that he has said here today without proof, it is even true? Okay, my second question. Is my client and his running mate academically qualified to be voted for? Is my client and his running mate having any disciplinary issues that declines him the legal right to be voted for? Okay. So the question is, how or why or on what basis did you disqualify my client?
Okay, thank you very much, Counsel. So there was a panel that was constituted which went through various stages of constitution. Your client, the petitioner was aware of the constitution of the. So after that, I think the day before the vetting, no, I think the day before the vetting started, the panel met your clients and you just had a few words with them.
Day before the vetting?
Not the day, but the day before the whole vetting process.
That's my client.
No, all client. Oh, I think he came late, so he wasn't. He didn't witness a lot of the meeting. But the issue here is the 8-member committee asked him various questions depending on his policy, knowledge. So there was the panel met and brainstormed the criteria and assigned marks to the criteria
before the vetting. Is that what you're saying?
Meeting the aspirants.
Start your whole statement again. Please, let's take very note of this.
There was a panel that was constituted.
Good.
And the constitution gives the right to the panel to form their criteria for vetting us. So that is what. So we first met the aspirants first as a panel.
Okay.
Then after which we tried brainstorming what we used to score each aspirant by criteria. So the criteria was set in such a way that it was going to be used for each and every aspirant. We didn't have that this aspirant will have. So that's what we did. So on the said vetting then, the petitioner appeared before the committee and there was an independent scoring by each member of the vetting committee. In our CI, we stated that to be qualified to run for elections, after the collation of oil results, we should be above or we should have 80%
to qualify.
To qualify to run in the elections. After adding the result from the 8 of the vetting panel, the aspirant scored 78.225. This meant that he didn't meet the 80% criteria, and that needed to be disqualified. That is why the candidate was disqualified.
Okay, so does the CI clearly give us the meaning of the word disqualification or to disqualify someone? Does the CI clearly give us a meaning to that? Yes or no?
No, but I think the Constitution.
Yes or no?
No.
Good. So, my Lord, a CI which is annexed to a constitution and it is a legal device shouldn't leave room for personal assumption and interpretation. And now here lies the case that the CI left room for personal assumption, and now the EC is assuming that if you are disqualified, it means you won't be given the right, or you won't be given the legal right to be voted for. But we can also assume that even though if you are disqualified and you are not having any legal basis that is with concern to your CGPA and your disciplinary issue, even though you have been disqualified, you'll be given the legal right to be voted for. The same incident happened in KNUST this year, that someone scored as low as 54%, yet still the person was given the opportunity to contest because they didn't find any GPA problem with the person nor any disciplinary problem with the person. So a constitution like this, like the CI, which is going to govern the entire affairs of this election, shouldn't leave room for personal interpretation, for you to interpret to us personally that the disqualification means you have taken the person legally out of the race. Okay. Now, my next question. In the scores and the criteria that you gave to us, according to the criteria that you gave to my client, I mean the responder you gave to my client, with the criteria over there, I'm going to ask you one after the other. So the first one is appearance. My question is, someone in a suit and a tie, how do you rate appearance?
Personally, I would like to say that this is from my personal point of view and does not represent.
No, please, you're representing the EC. So whatever that you say is for the EC.
We had a vetting panel, and everyone has a definition.
You are the chair of the vetting panel.
Yes.
So whatever you say.
But I made a statement earlier on council that the panel members have an independent scoring system. So what might be appreciable as a good appearance to me might not be appreciable to someone as a good appearance.
But I believe that you educated them on the criteria. So if appearance, there should be something that's the basis on which you actually classify someone to get a good appearance or a bad appearance.
Yes. So we did that, but the issue is the scoring of each thing. I do not influence the scoring.
Good. So
I hope you understand.
I understand what you're saying.
Yes.
So
when
from
you ask me how I should define appearance, I would tell them that the person must be presentable in an office wear. But you can be an office wear and the person scoring might have a different opinion, and I cannot say that because this person is in suit tie and it's in a nice shoe, you should score the person 10. I cannot do that.
Okay. So you said you educated them on how they should score the appearance. Is that right?
Everything on the scoring sheet.
Please, yes or no?
Yes.
You educated them on how to score the appearance.
Everything, please. Yes.
Yes.
Yes, please.
Good. So if you educated them and now you are now saying that you can't defend for them the marks that they gave, right?
Yes, please.
You can't defend for them the marks that they give.
Yes, please.
Can I also say that it means they also did the thing from their personal view, how they also wanted the thing to do, but not what you told them to do? Yes or no? Why?
Because as I said earlier, I educated everyone on what the person should look out for when they are scoring a particular point of the criteria. But I can't say that because this person did this, we should give this particular mark. Because I didn't put them on the panel. Some are from the parliament from which the petitioner comes from. Some are from the general student populace. Some are from the EC. So, me saying that I educated them that, if someone dressed very well, for example, how you are dressed, the person needs to be accorded a very good mark because he has really presented himself. But if you are wearing shabby shorts and stuff, that one cannot. But I can't say that Judge A scored maybe 8 out of 10 for appearance, so I influence that. No, I can't influence, but I educated them on what they should be looking out for. I hope you understand me, counsel.
When my client was being scored, or during his vetting
period,
were you around?
I wasn't, please.
Why?
I became week and I had to take some medications. And the thing too about it was I told the panel members that I won't be around. My head is on that day. It was just around this time, and I was feeling so unwell. So I made my first deputy to take over.
So, my lord, someone that we have instructed or we have given this peculiar work to you, and you are saying that you educated your people on how to go by the entire process, which means that whatever thing that happens in the entire process, you can be held responsible for that, since one, you educated them and then you confirm about that one. So if you tell us that you are not there and yet still there is something wrong with it, we can still blame you, because you are still supposed to be in charge of everything. Okay, to continue with my question.
Can I?
To continue with my question.
Yes, please.
Can you differentiate between current affairs and knowledge of SRC Constitution?
Yes, so current affairs
And then
are...
give example each.
Current affairs are anything happening. It can even be the... should I say... What is normally asked as current affairs, that who is this person, who is that person? Or it can even be...
Please give a proper example.
Okay, so it can be one. I'm giving 3 scenarios. It can be one. Someone can come and they ask you, do you know that there was a court hearing on this case? And the person will say yes or no. It's the current affair. 2. Do you know the justice of the... Do you know the Supreme... the Chief Justice of the Supreme Court? Yes. It can be a current affair. 3. Do you know that currently there is a legal document surrounding sexual harassment clause? It's also a current affair.
And what about the knowledge of UHAS SRC?
So UHAS SRC is happenings in the SRC. For example, do you know that currently maybe the SRC has built a court?
Good.
And do you know what went into how the SRC was able to fund everything? Do you know that the SRC, there was some budget brought before the SRC and were not accepted? They are all part of the SRC. Happenings. It's all part of the knowledge of the SRC.
Okay, so do you know that in the footage, that is the vetting, during the vetting of my client,
Yes, please.
there wasn't a single question that was asked on current affairs?
Please, why do you say so?
Did you watch the footage?
Yes, I watched the footage. And why did you say so, please?
Because there was no current affairs question. So that's why I'm telling you there's no current affairs question.
What's your metric for saying there was no current affairs question?
Because I have listened to the video, I've watched the video several times, and I didn't find any current affairs question.
According to your metric?
Yes.
Okay.
So do you know, do you also know that
I can't say I don't know, because there was a metric.
So, easy. You know, I can say that you didn't do your work well.
Why, please?
Because you don't even know something that you are supposed to do, something that you are supposed to know about it. You don't know. Someone that you have been given a responsibility to do something, you come to court and tell us that you don't know about it. Then what else do you know?
What do you say?
You said you don't know. I'm asking you a question. I'm asking you a question.
That's what I'm
saying. Do you know that?
The metric. You are using your own metric.
Okay, so according to your metrics.
The metric.
Yes.
The current affairs question was asked.
What was the current affairs question?
What was the current affairs?
Yes.
A lot of things were asked about the SRC, how procurement processes were going.
Good. So a lot of things were asked about the SRC, how procurements of things were going.
Yes.
So using current affairs and then knowledge concerning SRC, which one of them will you put that particular question under?
It can be under both.
Really?
Yes.
No.
Why so?
Because you don't know what you're talking about. My lord.
Counsel, please,
My lord.
I will not take that statement lightly. And
my lord, we all know that when you talk about current affairs, as he just said, it's about I know, but when you talk about current affairs, so when you talk about current affairs, it means the current happenings of the whatever thing that is going on in this world. Now, including UHAS, exactly. Now, in the criteria that they gave us, they actually specify a place for the knowledge of SRC, and then they specify a place for current affairs, which means that the knowledge, when you ask knowledge of SRC, you can't put that same question, or you can't give that same marks to the knowledge of the current affairs. And then secondly, the question that they asked my clients, that is the question that in quotes they say is a current affairs question, was a yes or no answer, and my client replied with a yes. So if my client replied with a yes or no answer with a yes, why then should you give 3.18 out of 5? Like, because the answer is yes, yes is yes. So why are you able to rate and then give the person 3.18 instead of 5? My next question. Okay, my lord, I rest my case.
All right, thank you very much, the legal counsel for the plaintiff, for the cross-examination. Justices.
Okay. So, my first question, is there any provision in the UHAS SRC constitution that the meeting between aspirants and EC after declaration of betting results, is there any provision in the UHAS SRC constitution?
None that I know of, please. So I don't know of any provision that prevents.
If there was no such provision in the UHAS SRC constitution, then why did the meeting happen?
It happened because one, I was contacted by the.
No, I'm saying that if there is no provision in the UHAS SRC constitution, why then did we have a meeting? Should we have had a meeting or we shouldn't?
I think you can decide to have the meeting.
No, if there's no provision in the UHAS SRC constitution, then there's no need for that.
My lord, please, there is no provision that says that the EC cannot candidate after. And there's also no provision that says that the EC can meet candidates.
So if there's no provision that stipulates that we cannot meet, and if there's no that does not bind us from meeting, does that mean that we should go ahead and have a meeting?
I think it depends on the discretion of the person to have a meeting.
Then it means that we shouldn't have had a meeting.
My lord, I don't get that, because there is no provision that says I can't meet, and there is no provision that says that I can't.
For example,
Decide to meet even after this court case, because in the constitution there is nowhere that says that after this place I can't meet you again.
but that is not a formal meeting. Do you understand? That's not a formal.
Yes, please.
Is there a provision on the next line of action? The UHAS
No, please. I think that is something that the.
is disqualified during a vetting committee.
Okay. Yes, there is a line of action there. The client is supposed to write to the EC asking for.
Which he did.
Yes, please.
And after he is not happy with it, what's the next line of action?
He goes to the SRC court.
So you should have come to the court, or?
The client or me.
I'm saying that the next line of action should have been the court.
Yes, please. Yes,
There's
please.
no need for a meeting between the EC and the client.
Okay, the meeting was brought about because.
I'm not looking for the relevance of the meeting.
Okay,
So
okay.
there was no need for a meeting between the EC and the client. True or false?
I wouldn't say false.
There's no this is a binary dichotomous variable. Yes or no? True or false? This is something.
I'll say false. I'll say
false. That's
Ye-
what you will stick.
Yes, please.
If there is an illegality, then it means that both you and the aspirant did an illegality, and so the question of meeting should be straight up for us to even, because the meeting in the was illegal.
Can I come in? Okay, so this meeting was prompted by a lot of factors.
Whether it's said, or it was not so for example, so far as someone feels like breaking the louver blades here, doesn't mean that you should do it. So
Yeah.
so far as there is a need for a meeting, doesn't mean that the meeting should have been held.
Yes, on that premise, please.
On that premise, there was no need for that meeting.
Yes, please.
Okay, the next question. No, don't worry, I worry a lot.
Oh, no, worry. I'll try, please.
With the composition of the criteria for the awards of the mark,
Yes, please.
were the aspirants given a copy of composition?
No, please. I don't think any vetting is being done with aspirants or.
Not that you don't think.
We didn't give them any.
But earlier on, there was this when you were going through the cross section by the plaintiff's attorney. He asked you a question and you said he had a prayer meeting before. So what?
Okay, in that meeting, he wanted to know any issues they had before started. Because as vetting panel, it requires that we meet aspirants before we start vetting.
So there was no. So they were not privy to the set of criteria.
We're looking
Okay.
at.
When you laid out your set of criteria, was there a definition to each set of criteria for the vetting committee?
Yes, please.
Was it penned down?
It wasn't penned down. We briefed.
No. Where was the evidence that you had that you
Because after that,
no, what was it penned down?
appearance, you need to be looking at this and this.
Yes.
No, it wasn't penned down, but we discussed
No.
as panel.
Whether you discuss or not.
Very well.
Penned down.
Very well.
It wasn't penned down. The only thing that will save you here is that the vetting committee, whatever you decide, it is up to you. But the thing is, those sets of criteria needed to have been penned down. Please, do you understand?
Yes.
So when you have appearance, this and this and this and that, you should define appearance, maybe tie, this and that and that. Please, do you get me?
Yes.
This one, this, that, and that, and that. So that when someone is answering that question, the person will be able to answer it really well. Okay, thank you.
Okay, so according to the petitioner, the counsel for the petitioner, he said from your CI, you didn't state exactly what happens if somebody gets disqualified from the vetting. Meaning, he says you opened it up for assumptions. And he cited clearly a case that happened in KNUST of somebody getting 54% from vetting results and a person still being allowed to run the election. Do you take responsibility for opening the disqualification without really specifying what it meant by somebody being disqualified from the vetting?
Okay. Thank you very much. I think petitioner failed to do something. At KNUST, when you are disqualified, there is a room to say that you are being given opportunity, which is stated in the CI. For them, like there is the opportunity to do that. We were using the premise. It wasn't an assumption because the constitution states that after you are disqualified, you can't run because that is what the constitution says. So we were saying that if you are disqualified, you can't be able to run. And the word disqualified there, we used it according to the definition that is, you can't run in the elections again. So I don't know whether it should have been disqualified, you can't run in the elections. That is what I am failing to understand. Yes, please.
So, Mr. EC, do you mean, if we get you right as justices, You mean since the CI is the annexation of the Constitution,
Yes, please.
we're running on the premise that since that article says that once you disqualify someone, it means that they can't run for an election, it applies to the CI. Is that what you're telling us?
Yes, please.
I think that's the clarity we want. That disqualification means that you can't run the election.
Honorable EC, please, I would like to take you to Chapter 6, Article 47, Composition of the Vetting Committee. It states that 1, should I read to you? 1, the chairperson of the Electoral Commission. B, we shall compose the deputy chair. C, 2 members of the SRC Parliament. And then 3, a legal advisor.
Yes, please.
Do you have a legal advisor on the panel when all this happened?
Yes, please.
You have a legal advisor. Thank you.
From the SRC Parliament, the legal advisor of the SRC was part of this, please.
Okay. Thank you. Can you tell us that the vetting panel is a fact-finding committee that you instituted?
Yes.
It's a fact-finding committee.
Yes, please.
I will take it to Article 46 of the SRC Constitution, Section C. Should I read or you have it there?
No, I don't have it.
The Section 6 states that the vetting committee shall have the power to disqualify any candidate for any election under the Constitution on the grounds stated only in the Constitution under Chapter 6 or Schedule 7.
Yes, please.
So, can you tell us that the disqualification of Mr. Bright is based on the Chapter 6, Schedule 7, either?
Yes, please. That's what it was based on, please.
It was based on Chapter 6, Schedule 7.
Yes.
So, can you, you know, that Schedule 7 or Chapter 6? Schedule 7 or Chapter 6, which one?
It's because it's annexed to the Constitution.
No, I want us to take it one after the other, because it says you can only disqualify. I think you can disqualify. You can only disqualify under the Chapter 6 or Schedule 7, which the CI. Should you go to the Schedule 7 and talk about what the
Constitution,
the Constitution?
Okay, I'm basing it on the constitutional instrument, please.
Because yes, please, because it's stated any candidate who does not get
80%. Yeah. Okay. I want to know the 80% mark. Was it predetermined by the Constitution, or is something you sat down to be that this is the criteria 80% you have to get?
It wasn't determined by the Constitution.
So you sat down to determine the 80% mark that you're supposed to get.
Yes, please. And presented it to Parliament for delegation.
Okay. So can you share with us why it should be an 80%, or is something that is classified? You want to do that in camera, or you would like the court to know that? Because it's a learning process. Anybody who is planning to probably contest an election next year will have it in mind that, okay, if I have to go for a vetting, these are the criteria I need to know. I think it's supposed to be a public document. I think so. Can you share with the court, or we have to do that in camera?
Please come again.
I mean, the basis for the 80% mark that you have to get before you.
Okay, so the 80% was looked at the various current a lot of what you need to get like an A. So we felt candidates to be able to price things that are coming from SRC. the 80% should be. It's a big position.
Okay.
The reason why I didn't put it at 60 or 70 is because we need the competition was also going to. We needed a criteria that would set out the voice from the men. So that is why we tried putting it at 80%.
Since you are raising the mark to 80, you have your student handbook, right?
Yes, please.
It was stated the criteria for you to get your A, to get your B, to get your C.
Yes, please.
So if you know these are going to be the marks for you to somebody to contest for an election, why don't you make it public that I'm getting 80%, I'm going before a vetting panel, I need to get an 80% mark before I should be able to qualify. Take it as a that. Can you explain the reason you kept that?
Please, we circulated the CI in the public domain.
Yes.
So all aspirants, we need it known to everyone.
That
80% pass. Yes, yes, please.
So my next question is, do you feel that the chapter 6 of the SRC Constitution, which talks about the GPA, which talks about any other legal actions or anything, are not enough for somebody to pass before going or picking up the form, that you have to probably institute a mark up to 80%? Do you think it's not enough?
I think it is not enough.
You think it's not enough?
Yes, for someone to run for an election.
Yes.
The reason being that although you can meet the GPA, you can meet all the other eligibility criteria stated in the Constitution, SRC is something that is so clear to everyone. So if you come there and we don't bring out policy that are smart, we don't do anything about the SRC, and you come there, there's a high possibility that you will come there and will be messing up because you don't know what to do. So the best thing as a process of the issues around it. Basing it just passing the eligibility criteria stated in the Constitution. I think so that's really difficult. Anyone at all can go there, but getting self-start, get to know the person later and get the person to systematic whether he'll be able to do.
Okay. My last question is, I want to ask is that, so the panel, how crucial the panel is going to be in determining who runs for the election. Have you done any background check for the various people who mounted the vetting panel? Have you done a background check that this person is not an ally to this candidate, this person don't have you done those various background checks for the various committee members that we are satisfied that those committee members are neutral person that mounted the panel that very day?
Personally, as EC, we didn't run a background check, but the issue was before you come on the panel, there's already a vetting panel before you come and join us on the vetting panel.
I can be good. I have said before a vetting panel, I pass the vetting panel because I know my agenda for the vetting. I can be very good enough, pass the vetting panel, go and then probably do my agenda do my bidding for my opponents. Are you aware that can happen?
Yes, yes. But the issue is, if the student populace bring 3 people, the Constitution does not allow the EC to say you are disqualified and this person cannot sit on the panel. If Parliament brings 2 people, the Constitution does not give the EC the power to say that these 2 people from Parliament, because they are aligned to this political party or this political person, they shouldn't sit on the panel. The Constitution does not allow that. The Constitution just says that these 2 people are from Parliament, these 2 people are this, these 2 people are this. So they be aligned to listen. I can't say that okay because this person is excuse me to say maybe it's in class with this person. Then the Constitution is qualified. The instance you can't do this because the criteria for being on the vetting panel is important. So it's a bit difficult for the institute to say that you look and do it because this and this.
Wow, quite intriguing that anybody at all from Parliament from anywhere can get, because the honorable member is a member of parliament. He has been there for a number of days there. He has been there. Maybe his colleagues from parliament can infiltrate the vetting panel and do his bidding as well. Could you imagine that could happen?
Yes, please. And that means we are trying to put parliament to the truth because because parliament is supposed to give us 2 minutes.
Yeah.
So if we say that his colleague can enter, his enemies can equally also enter. That means we'll be going around the whole process of trying to find a person of a person of integrity because we will not actually know the person's stance. Although the person join parliament.
No conflict of interest, right?
No question. About rules of leadership role was 5 marks. The mark given was 3.31. Current affairs, sorry. It was 3.182. And it was so can you please tell us
to state that the petitioner is only pushing the thing that this our first question that was asked in the vetting. That is according to his record. According to his record, he's saying that that was that is what he's saying. And also the result that it is not only from one person, it's from a coalition of the 5-member panel. So if we are going by now, that yes or no question, the council for the petition is taking it that the only question on current affairs was that, but I'm saying it is. So probably the current affairs questions or how you attend to other questions will inform the person's decisions on current affairs. Because I stated that it's only even because of who is this person or who is that person or who is this person. Questions to how to go through management. It's all a current affairs question. So for that, the issue is counsel for petitioner was trying to only spearhead one question, ask the current affairs question, and that was not the case over there. The whole vetting process, we asked both he and his wife questions on that. Based on the responses from various questions and a lot of factors, that's what amounted to the paper.
I don't seem to be satisfied by what you have told me.
I'm saying that defense question. That is according to him. He's saying that was the only current affairs question that was asked. Without making a point now, only current affairs question was asked. Because there are questions that were asked that are only current affairs. I hope you understand. The current affairs handling a lot of, not just asking one current affairs question and the rest will not answer. That is what I mean. So it could be that we're asking you further questions on this, further questions on policies, further questions on media. Some of the people they are moving from the current senator saying, how did you get on the and based on his answer, it informed our decision that we knew this was the current happenings in around Twitter. That is what the point I'm trying to prove.
You agree that you were not there on the day of the vetting?
No, it wasn't. I wasn't there. I started. I was present. Actually, my people.
So I'm sure because of this case, you would have definitely watched the full video of his vetting.
And
able to identify some of the reasons why he got that mark. Like for instance, you point out clearly which particular current affair question perhaps he didn't answer well that would make him fall short of the 5 marks that he's supposed to do.
My lord, there were several questions that were asked. I can't really pinpoint this particular question as saying, okay, as this is the only current affair. These were the only current affairs.
There's one thing that we need to get on record. One is, it is deemed that the vetting committee is competent because, one, the constitution is backing them. They gave them an opening for people to bring in and submit, come for vetting and other things, and they vetted them. Yeah, you chose people from parliament, and so it is deemed that what they are doing is competent. So they are people of competence. So they are competent people. I hope we all understand. And to the criteria to which they are going to do their work, no one is not spelled in the UHAS SRC constitution. Neither was it spelled in the CI that this is their set of. So in actual sense, if you are going to look at it, the SRC, UHAS SRC constitution is giving them a form of freedom to be able to actually demerit or merit someone based on their own set of criteria to make the person pass a vetting or not. And that's what is in the SRC constitution. So, not to dispute your point that you are raising, they are very, very nice points. But you see, on the face of the law, it needs to be able to bring in much substance. And so because the criteria has not been defined in the US SRC constitution, and they sat down to set their criteria, we can actually go down to look at the individual components of that criteria to look at the subjectivity and the objectivity of that criteria. Because why? Because that set of criteria, so for example, if and this one is saying this, another person, next panel that is there will also choose a different set of criteria. And those criteria have not been defined. If it was a predefined criteria, which has scoring systems, then that if someone looks at it, the person will have a problem. But here there's a little bit of allowance for subjectivity. And because the constitution gives an allowance for subjectivity, it means that we've put our trust in the committee to actually do a real work. And because we put our trust in the committee to do a real work, whatever they do, it is deemed appropriate. And that is where we need to be coming from, because you've put your substance of trust in the committee, and the constitution is binding them that they are competent people. What they do is binding, and it grants them the jurisdiction to actually demerit or merit someone. Please, counsel, do you understand? Because that's what the US SRC constitution is binding them to do. Because the constitution has that loophole of no certain criteria for passing someone. It has given that that authority to the committee to decide whether or not, and because the committee has the decision to decide whether or not, whatever they bring out, it is deemed appropriate. So if we are going to resign the decision of the committee, looking at their different base, every parameter, then we are trying to say that the committee is not competent. Please, do you get it? If you are going to resign the decision of the committee, then it means that the court here, we are going to say that the committee is not competent.
So I'd like to make some few clarifications. Under the Act of Enactment of 1905, whenever power is given to a particular authority or body to make a law or to make a rule, regardless of whatever subjectivity, whenever found liable that such authority is abused or misused in infringing upon someone's rights, that particular law or that particular component is repealed, revoked, annulled, or brought down because it's not deemed fit. Under the face of the law, everybody is equal, and everybody should enjoy same privileges and rights that everyone is supposed to enjoy. So regardless of whatever subjectivity, there must be a standard of work done. That's why even in healthcare, we are health professionals here, or we are student training to become health professionals. We have a standard of care. So whatever we are doing, whenever a patient comes, we expect you to do this and that and that. But where it is found that a power has been entrusted to you by the Constitution and you have not done due diligence, that particular component will be repealed or revoked because it seems to infringes on people's rights. So we have to get that clear.
But here is the case that each and every aspirant. You see that criteria that was said must apply to each and every aspirant. But this.
Council. Call you. All right. So, yes, council.
Yes. The issue here is they ask a yes or no question, and the marks that they give doesn't correspond to a yes or no question, because a yes or no question is either you get it right or you get it wrong. But here lies the case that the mark that was allocated for that particular one doesn't correspond to the yes or no question.
We are saying that all questions that was asked on current affairs was a yes.
Yes.
Client, but and so my question will still be directed to the electoral commissioner. You can take your seat, counsel. So, electoral commissioner, if I get you right, just for clarity's sake, you are saying that current affairs encompasses a lot of things. So it just tests how robust your knowledge is on an issue at the moment. So it can be anything at all, and you've given us instances which is true. So are you trying to say that their whole case about saying that it was only one current affairs question that was asked with yes or no is not what influenced the decision to get, is it 3.18? So there are a lot of other questions which were unsatisfactorily answered, which maybe if he had 5 in the yes or no, or maybe he's saying yes or maybe he's saying no, it's 5, but then because maybe he couldn't answer a lot of some other current affairs, so maybe with others he had maybe 1.2 or 2.6, and then the accumulated score for current affairs is what aggregates to the 3.18. Is that what you are saying?
Yes, my lord.
Okay, so if we go through the exhibit as justices and we are not able to find those instances, then you think that the justices here will be okay to hold that against the electoral commission?
No,
Why no?
because they are just only basing their. There are other things on
No,
the.
we are not saying that. Sorry to interject. We are not saying that the whole vetting was based on current affairs. Okay, so you said there are a lot of current affairs questions, and none of us are disputing that on this bench. Okay, what you are saying is that if you are able to go through the case and we find out that there were not enough current affairs cases, so it was just one current affairs case and it was just a yes or no, then we can override that aspect of we can question that subjective mark that exists, because I think yes or no is pretty objective, unless maybe there is a specific answer that you wanted, and I don't think yes. So if it's a yes, it's a yes. It's a no, it's a no. And secondly, too, I wanted to ask about, okay, so this is just a clarification. During the vetting, was there structured questions, as in when you come, then they will tell you that, okay, so I'm asking you about current affairs, so this is current, or they can just ask, maybe, what is the state of this? Because I remember they asking you about what is the state of the SRC coffers. SRC coffers, when we were talking about your policy for the JC and blah blah blah, right? All these things. What is the state of the coffers? All those things. They were not categorized. So I wanted to know from the EC if there was a categorization to say this is for current affairs, this is for state of SRC, this is for this is for this, or it was just a conglomeration of just like different angles of questions that they are, or like how do I say it, assessing. Do you get it? So we don't have a structure. Let's say move to state of SRC, they will move to this one, or I can ask you current affairs, then you ask about state of SRC, then she can also come and ask you about current affairs. So she's not labeling it. They are not labeling it. Then this one will come and ask you about maybe your policy document. This one will come and ask you about current affairs. How was the vetting?
So in the vetting process, what we did was we tried sharing rules among vetting to, but we didn't limit them. So we gave everyone a rule to focus more, but we didn't limit them. So maybe you should focus on this, but if you have the opportunity to delve more, or you've noticed something that wasn't well delved into, you can ask questions. So on the said vetting day, maybe I can do the introduction. Someone comes and asks more about your competencies. Someone asks about your knowledge of the SRC. Someone asks more about the current affairs. Someone asks about other things. So that is how the vetting went. At a point in time, there will be more focus on some other things than others. For example, your policy. So with the policy, we spend more time on policy. Although we had assigned to policy, but any other person can take the mic on that particular setting and ask you, oh, I read this and this, because you give 8 copies of your policy document to the panel. So on a particular setting, although we have assigned rules, about this, you ask more about this, you ask more about this. We tried as much as possible to make sure that each and every other person of the panel delve more into questions that are appropriate about any other thing the person is coming to say he's doing. So I would conclude by saying that although we assign rules to people, we didn't limit them in what they should ask. Okay, that.
Okay, so You stated in your submission that you were absent during his part of the vetting. And please, is that correct?
For some parts, yes, please.
For some part. Was it his part?
Yes, his part, for some part of the vote.
For some part of his part. Okay. And who took over from you?
My first deputy.
Your first deputy. How many do you have?
I have 2.
2.
Yes.
Okay, so in the vetting committee, chapter 6, article 47, it says that one deputy is supposed to be part. So is it the same deputy that took over after you, or it was another one?
So the first deputy acted in my stead. An EC member, because we are very limited in the EC. And 2 people are in Hall. So we are 3 down. And what happened on that stage is, when I was in I told them I wasn't feeling good to let him come and so it wasn't any throughout orientation, my EC members were orienting ourselves to go through each and every process. So some of them even traveled to meet to Wohoi in order to witness the vetting. So they were not new to this.
Okay, but my question is, was it 2 EC deputies that were there, or it was just one?
For the particular lesson, it was one and an EC member joined later.
And an EC member, was the EC member in your stead or in the stead of the deputy?
It was in the stead of the deputy. My first deputy was acting as my chair.
So what was the second deputy?
The second deputy is in Wohoi, please. And the other EC member is in Wohoi.
So the second deputy arranged with the EC member, or who arranged with the EC member?
The commission, we decided that this is what we are going to do. If one person is incapacitated, it's not really fair. That's all we.
Okay. Will you agree with me that since it's not an EC member in the vetting committee, you should have tried to make some arrangements for the second deputy to come?
Yes, I should have done that. But on the said day, he told me he had an eye. Yeah, he said he was very busy. He couldn't join us on the said
So he
day.
couldn't come. So then you decided to create an avenue for the next person.
Yes, it's not. I don't think the unilateral decision. Although I'm the chairman, we decide amongst us. This is what we are going to do if someone is not there, or so that we don't create a gap for an external person to come and act in the EC. Should a case where the EC member is not available.
Okay, so that means that at that time there were 8. There were 8 of them that gave him marks.
Yes, please. And after the lesson, I also vetted and I asked them what informed their decision to give such marks. Because I came back, and it was not only that I came back and asked them what informed their decision for this particular one and this part. They made it known to me, please.
All right. Thank you very much, the Electoral Commissioner, for your cross-examination. We are done with you, so you can take your seat.
Thank you very much, my lord.
The court will go on recess for 20 minutes. For 20 minutes, and then we will come back for closing statements and any other thing you want to say to the court. So yes, Mr. Rexford, you can take your seat. The court is now on recess.
whole campaign. And then it shows a statement that reads, it's a fraudulent agenda the EC and then the bias panel are pushing. And we are so much aware. We shall deal with this issue to the very core. Let's keep hope alive. With this statement, I believe the petitioner is actually questioning the credibility of the whole vetting panel and the EC. And so I would like to ask the court, why should the petitioner come back to say he wants to make inquiries about how the whole criteria brought about the scores and everything, if he views the EC and then the vetting panel controlling the whole vetting process as a biased panel and the EC trying to push a fraudulent agenda?
Response to that.
I am having one. Okay, my lord. So, to the answer to the questions that the defendant asked. So the first one is that it's because my client, Mr. Vapor, wasn't satisfied with the response that they gave him. That was the reason why he gave that comment. And then with the talking about the vetting panel, we realized that from when the EC was talking, he made mention that when he left, they brought another person to represent him. Now the question is that the person that represented the EC wasn't vetted, but yet still the person was brought to added to the vetting panel to actually vet my client. So this unqualified, in quotes, unqualified person that was brought to.
Please, I would like to make it clear that people from the EC are not supposed to be vetted. And so your grounds for argument is?
But constitutionally, were they supposed to be part of the panel?
Yes.
That particular person that you brought, was the person supposed to be part of the panel? Constitutionally.
It says that the deputy,
No, the question is that the person that you brought on the panel, the additional person that you brought on the panel, when the EC left, constitutionally, was the person supposed to be there?
The person is a member of the EC, and then
the question is, constitutionally, was the person supposed to be there, yes or no?
The plaintiff to continue with the point you were making.
Okay. So, because the person wasn't vetted, the person is not qualified enough to be part of the vetting panel. So because of that, it made the whole vetting panel also unqualified, because they've actually brought someone who is unqualified to be part of the vetting panel. Thank you very much.
So, if we get you clear, you are now expanding the scope of your case to cover the vetting panel. So the whole vetting panel.
So from the from the question that he wants to bring up.
Yes.
That
so is your answer to the question
exactly
implying that the whole vetting panel is fraudulent, and so the whole vetting process is fraudulent? What exactly are you saying?
Okay, so what I am saying is that they brought someone who is not who is unqualified to be part of the vetting panel during my client's time. So it was only during my client's time that that particular thing happened, that they brought someone who was unqualified to be part of the vetting panel. And because of that, it has actually made the whole vetting panel like a fault, or there's a question mark with the whole vetting panel. Yes. So,
if we get you right, I get the what you want to drive is that it is all the electoral commission of who
So
how are you aware that there is a fraudulent agenda that the panel is pushing? Can you do that to us? How you are aware?
So
From there, you are fully aware that there's no doubt you are aware.
okay, so the issue that we are raising is that the person that they added to the vetting panel is not supposed to be there. Now, this only happened during my client's time. So it means that with the other vetting, everything was okay, everything was cool. So the reason why he actually used that word fraudulent means that, okay.
I would like to make it clear that your client wasn't the only one who was vetted. His vice too was vetted, and so
I think at this point they are one. So if you are talking about my client, it means I'm equally talking about my vice, his vice too as well.
yes, and another aspirant was also vetted by the same board you claim to be biased and trying to push a fraudulent agenda.
So the thing is that the reason why this whole thing is coming up is because of the message that you are reading.
Yes.
Is that true?
Yes.
Right.
Because he clearly
So
states
yes.
here-
So the reason I'm telling you the reason why he actually said that statement. So whether it implies to other people, then those people can also say the same thing.
So, can you make clear to the court which other candidate was vetted by that constitution of panel that vetted the plaintiff?
Okay. The aspirant Honorable Franchati was also vetted by the same board.
So if we go and play the video on YouTube, on UHAS-based TV, they are going to see that the Honorable Frank Chatti, right, was vetted by that same panel without the EC chairman, that is for Dasa,
Yes.
on the panel.
Yes, please.
Okay.
Objection, my lord. Objection, my lord. My lord. So from all the communication that we have so far, and then from what the EC said, he actually said that he left during my client's time. It was clear. That's what he said. So he didn't leave during Honorable Chatti's time or something.
No, he wasn't the last. Frank, no, it vetted Frank Chatti before. Yes, please. Yes, sorry, it was rather Frank Chatti's own that I left earlier. Yeah, sorry, I thought it was right. Yes, please. Yeah, that ended it. Yes, please. Yes, please.
Please, may I address the plaintiff? Yes. Yes. I want to. So, yes, please. Please, at the beginning of the whole session, what you use, I would like you to confirm for me. Did you make a statement that you don't have a problem with the EC itself? Yes, and you don't. Please, can you read it for me? Yes.
We are not against the application of the constitutional instrument in the conduct of the election, as stated in the Article 6, Chapter 6, Article 44 of the UHAS Constitution. 2. We are not against the electoral commissioner as a person, but the conduct of his office. 3. We are not against the members of the vetting panel, but against the conduct of which their work was carried out.
Can you elaborate what you mean by conduct? Like, I don't get.
Can I
Can
elaborate?
you just give a summary of what you mean by conduct?
Okay, so the conduct here is we are talking about one, the style or the way they performed their duties, how they carried about with their duty. That is what we are talking about.
You are saying that you are not against the panel itself, but their conduct. So, if I understand you right, from what you just said, does it mean that the constituents of the panel, is it part of the conduct or is not part? As in
Come
the
again.
people that were in the panel. Because you said you are not against the panel, but you are against the conduct. The constitution of the panel, is it a conduct?
This part.
It's a conduct.
Yes. So the thing is that the meaning of that actual statement is that we are not against someone, maybe because like on a personal base, that maybe someone, maybe we are having a grudge against someone, so we are attacking the person on that personal base. So it's like how they carried about with their work, how they conducted or performed their duty. That is how we actually have a problem with, but not personally against the person who like did it individually.
Counsel, there's a tension in your case, and I want you to clarify it.
Okay.
You are saying that you are not against the panel, right? And you are then saying again that you are against the conduct, and so, but yes, and now you are saying that you are not against how they went about in doing their job, but your whole case is premised on the idea that they didn't mark you well, okay? Which is also a way of they going about in doing their job. So are you against that way they are going? Because if you are saying you are not against the way they did their job, then it means that you are okay with the marks you were given. So, yes, give us the clarification. So, what was the conduct in which their work was carried out, specifically in about 3 to 4 lines? Summarize the conduct which you are referring to, which is something that you are against for us.
Bringing someone who is unqualified or someone who is not fit to be vetted, to vet my client, to be part of the vetting panel, to vet him. The scores, the scores that was allocated to him is unsatisfactory. Yes.
And that constitutional person you are attacking, which was supposed to be part of the panel, constitutes that panel. So for the panel in question that you are arguing against, means that you are not against that panel. So I don't get that line. And am I going to put that in the that line? Because how can you not be against a panel that constitutes that unconstitutional member, and have a problem with the conduct of the non-constitutional member? I think you have to be against it, because that panel constitutes that unconstitutional member.
My lord, you are confusing me.
I think this one is actually maybe as the process, the proceedings are going on. They are now trying to draw the subject into a bit because the table is for the fact that you are amending anything because you don't want to put questions in your mouth. So if you are amending it, you have to then.
We are not amending anything.
You are amending it so that.
No, looking at the EC's own. Do you know the EC's statement, the one that I made for the EC? I said we are not against the electoral commissioner as a person. So in that same understanding, as a person, we are not against the vetting panel. So yes, please. Yes. So the correction is that we are not against the vetting panel as individuals, or the various members of the vetting panels as individuals, but against the conduct of which their work was carried out. Thank you.
We will now move to the closing statement. Closing statement for plaintiff. 10 minutes.
So the closing statements. The constitutional instrument of the electoral commissioner did not clearly state what it means to be disqualified. Therefore, my lord, the electoral commissioner has no legal right to take my client, Mr. Vapor Bright, off the election race. 2. My client was not asked any question on current affairs, but was scored 3.18 on the score sheet as indicated in the EC's letter with reference UHAS SRC /EC/2022 stroke 007. How then this mark come about? Point 3. The EC's dealing must be probably investigated and brought to book for holding a clandestine meeting with my client to cajole him to accept the unlawful qualification. The EC, in his absence, brought in an unqualified person because the person wasn't vetted to replace him. This make the vetting panel who vetted my client legally unqualified. Thank you. I rest my case.
So thank you, the legal counsel for the plaintiff, for your closing statement. Shall we invite the legal counsel for the defendant for your closing statement?
Okay, my lord, thank you. For my closing statement, I'll first like to make clarification on the fact that before any member is allowed to join the EC, they are being vetted, and then that makes the statement that the member of which the EC presented to join the committee is unqualified factually wrong, since he was being vetted before he joined the EC. And then secondly, with the issue of the EC chair stepping out and then his deputy taking over for a member of the EC to join the panel, this occurred because the health of the EC chair was at stake, and it was an emergency as at that time. And the EC, during his cross-examination, made it clear that provisions could not be made for the second deputy to be available as at that time. And so that also confirms the fact that the member being asked to join the panel, it's right, since it was a decision made by the EC board. No. Also, I would like to make clear that the basis for qualification is Chapter 6 or Schedule 7. Schedule 7 or Chapter 6 are the basis or the grounds for disqualification. And therefore, the statement that the basis for qualification is on Chapter 6, Article 38, it's contradictory. Since I would like to cite an example of one Mr. Jeffrey Opata, an aspirant in the 2018-2019, an aspirant in the 2018-2019 SRC elections of the UHAS SRC. He was disqualified on the basis of allegedly forging signatures of students, and that contradicted the Schedule 7. And so his basis of disqualification wasn't solely on Chapter 6, Article 38, as they claim. And then he also mentioned that the EC has no right to disqualify the petitioner from running in an election. But it's stated in the Constitution that the aspirant, when disqualified, cannot run in the SRC elections. And hence, I believe that the statement he made is also factually incorrect, since once the client is seen as unqualified, cannot run in the elections, and hence what the EC is claiming is actually having factual basis and should be heard. I rest my case.
So, once again, good morning. We've come to the end of today's hearing, and the justices would sit on all the evidences, cases, arguments, engagements that have happened here, and the pre-trial and this trial. We take everything into consideration and we will deliver a verdict. So we deliver a verdict which is going to be a written statement to each of the parties and then to the general public, latest by Tuesday evening, 5 p.m. The verdict should be ready to be delivered. Thank you very much. The court is now adjourned.